Welcome to Tutorials on the Go. This is a maiden edition of our study on global law. So there's an introduction. To discuss global law, we'll first have to look at a political economy, what it is. A country's political economy normally refers to an interrelationship between its economic, political, and legal system. So these systems are independent, but they interact and influence how each of them will play out. Okay, so the political and economic system of a country will normally be impacted upon by that jurisdiction's legal system, and it will have an impact on how international business roll out. So we'll look at them one after the other. We're going to start with the economic system. So the economic system deals with how a country or a state or a jurisdiction finances itself, how it raises resources to be able to cater for its expenditure. So it deals with what that state has to produce, how it is going to produce what it has identified, and the recipient or the intended users of the produce. There are three main types of the economic system. We have the planned, the market, and the mixed. So the planned has to do with decisions and choices that are made by the government. So how the resources in the country has to be utilized and at what prices it should be paid for to access them. In the market section, the decisions and choices are left to the market forces, that is demand and supply. So the availability of the product will impact the price at which it will be available to access them. So the more it is available, the less pricey it will be, and then vice versa. So the basic tenets of economics. Then the mixed has to do with a mixture of the two. So the government helps in deciding the economic playouts. Then the market also caters for a portion. So in most countries, it is the mixed that is prevalent. We don't have a system where it is solely government calling the shots, or a country where it is only the interaction of demand and supply. There are systems where government has to step in when things might go haywire. Okay, when demand is so high, suppliers might be taking advantage of consumers by charging exorbitant prices. So the government has to step in and then regulate that system. In situations where supply is also high, demand will force the prices low, which might not augur well for industry. So government might also step in and then try to fix or regulate prices. The political system has to do with how a country is managed. So it can be administered by a dictator where individual freedom is heavily regulated. People do not have the liberty to decide what they want or has to do. Or it can be managed by an elected body where individuals are highly free, or the regulation is minimally low, but then they will also be expected to abide by enacted laws and regulations. And we'll come to the last portion, the legal system. It is a set of rules which is supposed to regulate members or people residing within a jurisdiction, a state, a country, or a district. So laws are understood in jurisdictional terms. So a law that might be applicable in one country might be forbidden in another. In the US, there are certain states that permit certain actions with their laws, but other states abhor it. The laws are normally contained in the country's constitution. That is what is used to govern the nation. And it is established by the people running the nation. Now, many countries normally have a written constitution, but then increasingly, people move to other countries or other states for trading purposes. So somebody might move from Ghana to the US or from the UK to the Switzerland to trade. So if a law that is applicable in the UK is not permissible in Switzerland, that means that there's going to be a bit of a challenge. This is where international or global law comes in order to smoothen international commercial transactions. We look at separation of powers. So this is normally an ancient principle that looks at how powers in a country is administered. So the aim is to ensure that one human being or a body of institution does not wield excessive power. So in modern thinking, governmental powers are analyzed into three. We have the legislature, who propounds law. We have the executive, who implements the law propounded by the legislature. And then the judiciary interprets the law in situations where there is a fracas. They are primarily the lawmakers in the state. Their makeup will usually indicate whether the state is considered to be democratic or not by its membership. Okay, if its membership is elected, then it can be deemed to be democratic. But if it's just handpicked, then it connotes autocracy. Now, they may either have unlimited power to make laws, in which case they can be deemed to be sovereign or supreme, or they might be subject to legal limits on their power. In this case, they will be deemed to be subordinate. So subordinate means that they will be accountable to, or laws that are made can be rendered invalid by the judiciary. So one of the key rules of UK's unwritten constitution is that the UK Parliament is sovereign, meaning the courts, that is the judiciary, have no power to declare any law that they pass as invalid. Now, if a law is made by Parliament is deemed to be flawed, then it lies on the same Parliament to rule it out. The next is executive. So they will implement the laws that the legislature propounds. So they usually have the numerical powers of all the three. So they consist of the central and local governments, the civil service, ministers, the police force, the armed forces, the tax authorities. Then in a state that seeks to fully practice separation of powers, such as the France, the US, will be largely independent of the legislature and the judiciary. In the state that follows the Westminster model, that is the one practiced in the UK, most members of the executive must come from the legislature. Now we come to the judiciary. They decide authoritatively questions that arise about the law that has been propounded. So in cases of conflict, they will bring clarity. So the judicial activity may be classified as criminal. That is, matters that are brought between the state and individuals. And it can be civil. That is, issues between individuals. Okay, so one person against the other, or one person against another institution. They are usually wholly or largely outside the legislative process. So where a legislature is not sovereign, then the judiciary will have powers to declare laws that they have propounded as unconstitutional and then invalid.